Hello, Michigan Realtors, and welcome back to another installment of Letter of the Law. Today we will be discussing Michigan Realtors buyer agency forms, Forms J and JJ, respectively. Now, realtors who use one of these forms or any other buyer agency form should become very familiar with the provisions. A realtor should not simply hand their clients a buyer's agency contract and ask them to sign it. A realtor should be prepared to go over the contract with their clients paragraph by paragraph, so that the clients fully understand the relationship. Now, with that preamble, let's review the major provisions in the Michigan Realtors form. As a first consideration, traditional agency offices should use Form J, whereas designated agency offices should use Form JJ. The difference is that in a designated agency office, individual agents can represent different parties in a transaction and do not need to become dual agents. However, executing the agreement within a designated agency office is imperative to remain a designated agency firm. Failure to utilize a buyer's brokerage form in a designated agency firm will default that firm to traditional agency and could potentially cause numerous unintended consequences, such as non-consensual dual agency. Number 2, the contract explains the buyer's agent's role, what the buyer agents can do and cannot do for the buyer. Now, lawyers representing real estate licensees tend to focus on making sure that clients understand what services buyer's agents won't provide. While this is important, when reviewing this contract with a potential buyer client, buyer's agent should also discuss the services that they do provide, such as formulating acquisition and negotiation strategies. Buyer's agents should be prepared to explain their value. Number 3, the contract also sets out the compensation that the buyer is obligated to pay the buyer's broker. Now, the contract makes clear that the commission amount is not fixed by the MLS or anyone else. Buyers should understand that commissions are a matter of negotiation between the buyer's broker and the buyer. There are alternative compensation choices that a buyer's broker may offer, but is not required to offer, such as an hourly fee, flat fee, or a percentage commission. Number 4, the contract also says that if a buyer's broker gets compensated from the seller and/or the listing broker, that payment amount will be credited against the amount the buyer is obligated to pay. Buyer's agent should never suggest to their buyer clients that the listing broker and/or seller is obligated to assume this responsibility, or that for whatever reason the buyer need not be concerned about this obligation. Under the contract, the buyer's broker's commission is the buyer's responsibility, unless the listing broker and/or the seller contractually agree to pay it. Number 5, if a payment by the seller or listing broker to the buyer's broker is less than the compensation that the buyer agreed to pay, the buyer will be responsible for the shortfall. On the other hand, a buyer's broker is entitled to the entire commission amount offered by the seller or listing broker, even if it exceeds the amount the buyer agreed to pay. Number 6, a buyer's agent owes a buyer a duty of full disclosure. However, the contract has the buyer agree that this disclosure duty will not apply to confidential information learned by the buyer's agent in another agency relationship. Number 7, remember, with existing clients, your duty of loyalty prevents you from disclosing any information that your client does not want disclosed, even if it is not confidential. However, there is no duty of loyalty owed to former clients. Once they become a former client, your only duty is to preserve confidential information. Not all information you learn about a client is confidential. If the information is public, or if the other side in a failed transaction is aware of this information, it is not confidential. Agents must understand this distinction because if information about a prior client is not confidential, an agent has an obligation to disclose that information to their new client. Number 8, the contract discusses the possibility of the buyer's agent representing more than one buyer interested in the same home. This is not dual agency, but it is a conflict of interest. In this situation, buyer's agent cannot disclose one buyer client's negotiating strategy with another buyer client. In a traditional agency firm, there is a conflict of interest even if the competing buyers are represented by different agents within the same firm. Number 9. The contract discusses the possibility of the buyer's agent representing both buyer and seller. Parties should agree ahead of time as to what will happen. Buyer's agent can become a dual agent, a transaction coordinator, or can terminate their agency relationship with the buyer and represent only the seller. Of course, in a traditional agency firm, agents in the same firm cannot represent different parties in the transaction. I hope the information provided in this segment gives you a meaningful overview of the Michigan Realtors buyer agency form, as well as some best practices pertaining to buyer's agency. Now, having these meaningful conversations with clients about the important work that you do has never been more important. If you have any questions about the form, please don't hesitate to reach out to the email at the bottom of the screen. We also hope this video finds you in possession of the new Michigan Realtors Legal Hotline Companion. It includes some new sections and features even more legal references. Please consider it a portable resource for your business. Thanks for watching, and until next time, stay safe out there.